In a nutshell, the Supreme Court's decision in Students for Fair Admission versus Harvard and versus UNC held that the school's admissions programs violated the Equal Protection Clause by making admissions decisions based on applicants' race. In terms of the impact on corporate DE&I programs, I think the principal impact has been the focus that it has brought to those programs. While the Supreme Court's decision didn't actually change the laws related to employment discrimination, it did give us some insight into the court's skepticism, I'll call it, with respect to corporate DE&I programs. And also it has certainly fanned the flames of challenges to those programs since the decision was issued.
At O'Melveny, we started a working group a few months before the Supreme Court's decision, thinking about what the implications might be from this higher education case outside of the higher education context, thinking there may be ripple effects. In the months since the Supreme Court's decision, we have certainly seen ripple effects, primarily in terms of new lawsuits being filed, new legal theories being tested, but also in recent months, some initial decisions sketching out what the landscape might be in terms of implications from the higher education decision outside of the higher education context.
Companies are facing a variety of challenges to their corporate DE&I programs, ranging from reverse discrimination claims under Title VII filed by employees related to hiring and promotion decisions, or to mentoring and education opportunities, to shareholder lawsuits where the plaintiffs are claiming that the board of directors violated their fiduciary duty by allowing these DE&I programs to be adopted. And in that context, we are seeing a focus on the company's ESG materials that are often publicly available. We're also seeing claims in the context of diversity fellowships, bonuses, and grants. And then on top of that, we're also seeing some congressional inquiries in this area. So that is a new area that we are seeing more activity in recent days.
The DEI litigation landscape has been really significant for boards of directors of corporations for two primary reasons. First, in terms of the selection criteria for boards of directors, it has often been the case in recent years that boards have identified and companies have identified selection criteria for board members that involve racial diversity, that involve gender diversity, and those board selection criteria have been the subject of state laws, for example, in places like California. They've also been the subject of regulatory requirements or requirements from organizations like NASDAQ. And there's been interesting developments regarding those requirements for the board members themselves. The second reason that the DEI litigation landscape has been relevant to boards of directors is that in recent years, DEI policies at corporations have often been board level issues. So while it's not always the case that employment policies or workforce decisions are before boards of directors, it has often been the case in recent years that boards are considering, both in terms of ESG and DEI specifically, what their DEI commitments, their DEI goals, and DEI values are. And so to the extent there are emerging claims about the lawfulness of those policies and the fiduciary duties of boards and officers of corporations, the DEI litigation landscape has been very much a board level issue in recent months. One thing I suspect that we might see in the coming months and years are buckets of litigation where different programs, different types of DEI policies, both in terms of the workforce, in terms of hiring, promotion, compensation, but also in terms of supplier diversity policies, are litigated to test out new legal theories to determine what exactly the implications are from the Supreme Court's decision on different categories of DEI policies.
I think coming up in the next year, we are focused on the Supreme Court's decision in Muldrow versus City of St. Louis. The court recently heard argument in that case, and the decision there could determine whether Title VII requires a significant disadvantage in order to state an actionable claim. If the court says no, then I think we can expect to see a lot more in the context of litigation challenging corporate DE&I programs.